Welcome to the Law in Context podcast.
I'm Emeritus Professor Stephen Bottomley, former Dean of Law at the Australian National University in Canberra.
And I'm Emeritus Professor Stephen Parker, former Dean of Law at Monash University in Melbourne.
Between us, we have written books and articles on corporations law, lawyers' ethics, family law and many other legal topics.
In most episodes, we take a legal topic of interest, perhaps one that's in the news, and relate it back to fundamental questions about the legal system.
So whether you are a member of the public wanting to know more about law and make sense of what is in the news, or you are studying legal studies, criminology, or even a law degree, our plan is to help you with a deeper understanding of what is going on.
So far in this podcast series, we have sidestepped an important question. What is justice? We did have an episode on access to justice, which was basically about access to impartial adjudication and perhaps to alternative forms of dispute resolution. And next time, we will finally confront the question, what is law? But we're trying to build the suspense and develop our listeners' understanding layer upon layer.
So far, we've taken a formalistic or procedural approach. If the law is constitutional, the judge is impartial, the rules of evidence are followed, and the jury system works as it should, then the outcome is legally just. And there are people who say that this kind of formal justice is the best we can aim for. Everything else is simply personal preference. But almost every day we hear people talk about unjust decisions, even though the rules have been followed. They must be getting at a deeper sense of justice, something that lies behind formal procedures, a substantive idea of justice.
So, in this episode, we'll have a go at disentangling some of the main ideas about justice, including schools of thought that go back centuries, but we do so from the legal perspective. Non-legal schools of thought about justice do filter into our thinking about law, as we'll hear, but form and procedure are our starting point.
Formal ideas of justice are captured by expressions such as due process. And they are very important to the functioning of a society. There is plenty of research to show that when people know the rules have been applied in a fair way, with both sides having the opportunity to make their case to an impartial adjudicator, they will accept outcomes that they are nevertheless unhappy with. This suggests that the ideas of justice and fairness are closely tied. It is symbolised in the iconic statue of Justitia, a blindfolded woman holding a set of scales. The blindfold is meant to symbolise the impartiality of law. Scales can tip either way. But the blindfold might also suggest that the law doesn't see inequality.
Justitia is actually our podcast logo, but we've taken her blindfold off, similar to the equivalent Greek goddess Themis, to indicate our own uncertainty, and we brought her up to date with headphones in the hope that she's listening.
Fairness on its own can't be sufficient, though. Starting a game with a coin toss is regarded as a fair process, but there is no particular merit in one side of the coin over the other. Historically, some legal disputes were decided by equivalent processes. The trial by ordeal is an example, but no one these days would regard that as rational, even though it is formal.
So, for a formal procedure to be just, it does have to be relevant to its context. A coin toss for a game, yes, but rules of evidence and impartial judging for a dispute. This means there is still some substantive idea of relevance behind it, not just procedure for its own sake.
We can move on from fairness to look at three other overlapping approaches to substantive justice, which help to organise some of the major ideas in this area. The first is justice as equality. The provision of legal aid is an example. Yes, someone who cannot afford legal representation can stand in court and say their piece, but if they don't understand the law, are adrift with court procedure, and are not articulate, they will be little match for an opponent who can afford a trained lawyer, especially in an adversarial system where the judge is supposed to be passive until the end.
The Castle was a funny Australian movie, but that's all it was. An unequal fight is not usually thought of as a just one. So, concerns to promote access to justice can be seen as stemming from the notion that equality is at least a component part of justice. However, the equality movement has motivated feminist and other critical approaches to law way beyond access to justice questions. It has pushed the common law into changing. It helps explain why the High Court, in the case of Mabo, managed to find that Australia's First Nations people may be entitled to particular forms of land rights when in earlier years no court would go that way.
A second substantive approach to justice is justice as desert. This is sometimes called retributive justice. You should get what you deserve, what is due to you, what you have merited. In criminal law, for example, sentences should be proportionate to the crime. So people will complain if they think that the sentence was too lenient, the defendant didn't get what they deserved, or too severe, they didn't deserve what they got. A deserts theory underpins contract law, to give another example. If you have given something in return, what the law calls consideration, you deserve to have the bargain enforced. And it underpins the law of torts. If someone has caused you harm by their negligence, you deserve to be compensated.
A third substantive approach to justice is justice as entitlement or justice as rights. A just legal system protects people's rights, and if it fails to live up to what someone regards as a right, they may say it is unjust. Although this kind of thinking goes back centuries, in particular to the idea that there are natural rights, it received a major boost in the mid-20th century with the flowering of the idea of human rights. A law that does not protect, or perhaps even promote, human rights is unjust from this perspective.
Drawing these distinctions between equality, deserts, and rights might help us put particular thinkers into their separate piles, but the problem is that it is all attractive in some way. We want fair procedure. We do think that at some level people are equal. We do want deserving outcomes, and rights should be respected.
It's easy to look backwards to see how the law has developed in its higgledy-piggledy way, to use a technical legal expression, buffeted by these competing ideas of justice. But looking forwards, when you have a dispute to decide in the here and now, you couldn't have a legal system where it's always open slather, where a judge's own preferred substantive idea of justice is what will win the day, at least not if you value the rule of law. In common law systems, you have to treat like cases alike, a procedural notion, and in inquisitorial systems, you have to apply the legal code in a good faith manner. When faced with an everyday dispute to handle, it is the procedural approach to justice that has to keep us all on the rails.
Having said this, substantive ideas of justice help us critique the law and advocate for change, for example, to parliamentarians. And in those moments where there are gaps in the law, where an appeal court could go either way, the more substantive theories of justice can guide a decision maker to an outcome which nudges the law along. In the next episode on What is Law, we will see that the legal philosopher Ronald Dworkin argues that this is how morality becomes part of law.
We said earlier that we would stay on the legal end of philosophy, but there is one thinker who offers a mechanism to order our thoughts. John Rawls wrote a hugely influential book called A Theory of Justice, where he asked how you could design a fair society. If we were all behind a veil of ignorance, as he called it, so we didn't know how we were placed, how lucky we were, how privileged we were, and so on, how would we design a just society? He said that we would go for two principles. First, we would protect basic liberty to the extent compatible with the liberty of others. Second, we would only allow inequalities if they result in compensating benefits for everyone.
Perhaps then we should push for law reform that applies these two principles, promoting basic liberty to the extent compatible with curbing inequality. Because behind our imaginary veil of ignorance, we cannot know when we will need them. But on a day-to-day basis, you have to apply established procedures. Otherwise, you are stepping outside the sphere of law.
My personal view is that no universal theory of justice could possibly handle every issue. How wealth should be distributed in society, how to decide reparation after war, whether the descendants of slave owners should compensate the descendants of slaves, and so on. Courts themselves usually take this view, and only take on cases that are said to be justiciable, meaning capable of being tried in a court of law.
I can go along with that.
Thank you for listening to this episode. You can find more episodes in this gripping series at lawincontext.com.au or wherever you get your podcasts.
Over time, we will build up resources on the website with further exciting reading on the topics we've discussed.
We're the two Steves, and that was a Law in Context podcast.
As the two Ronnies used to say,
it's goodbye from me.
And it's goodbye from him.
Bye. Phew, I'm glad that one's over. It's complicated stuff.
Actually, I thought you did the topic justice.
In what sense?
You're obviously behind a veil of ignorance.